Trying to find a glitch. I think I found it. Hopefully we good. I don't know. I was trying to figure it out, but I think I did. I don't know what happened, but they tried, or whatever tried. But we ain't gonna let that stop us from doing what we gotta do. So y'all come on back up in here. And let's finish up. Time to finish up. We're gonna get it done one way or another. Man, I'm actually live on like 4 or 5 different platforms right now, so it was echoing in all of it. So but I know which one it was. I found out which one. So we good. We're gonna be alright. All right, it's time. Let me let the people see what they want to see. Let's go. Alrighty. Make sure y'all hit the share button. We are on Facebook. We're on Twitch and TikTok right now. We'll be on Instagram soon. I just ain't set it up yet, but we'll be on there too. Yeah, we'll be on there too. Straight up. Well, I appreciate you being here with us then, Chronos Draco. So, how you like it so far? Let's go. All right, we back. Had a little technical difficulties here, but we are definitely going to finish up what we started and deliver this to the people as we are talking about unconstitutional gun charges, all right? And just picking up back where we left off, it is your right to bear arms, and that's one thing that you have to understand, right? So before we continue forward, everything that you hear is for educational and religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor, as it is my religious duty to speak my religious truth and experience with you guys here today, all right? So, yeah. Let's talk about it, right? So how do beat a non-violent gun charge? How do you do it? And remember, non-violent. So everything always comes to one thing when it comes to this type of charge. Can they prove willful intent of you disobeying the law? Like, can they prove that? Can they prove that you are willfully going to make a threat against someone or has made a threat to make war and cause harm? Can they show that you were not using it or having it in self-defense? That's what they have to be able to prove. But the thing is, this question is never brought up. You guys just roll with the punches and feel like you were supposed to be hiding this gun, or you didn't hold it the way they told you that you could hold it, and things of that nature, right? So you end up in a position to where now you got, gun charge, and you got to pay restitution for some stuff. You end up on probation and all this unconstitutional stuff that just happens to you. And that is wild, right? So we're going to give you guys the remedy here on what to do, and we're going to make it happen right now. Okay, I did this for someone in Texas, and they had an actual, and actually they were on probation, and they end up with a gun charge. And so we end up getting all of that discharged. All the gun charges got discharged. And it was a very simple method because all we had to do is exercise their right. And we're going to show you guys in two different ways how to do that. And if you are an appreciative of this, all I ask that you do is share this. All right. And as long as we can agree that you're going to share, then we're going to continue on. So drop some ones and hit that share button so I know that we good. Hold up your end of the bargain so I can hold up mine. Hold up your end of the bargain. That's all I need. Oh, beautiful numbers up there. 11111. I will accept that. We will go on that note. So, all right, this is a notice of abatement of action for lack of jurisdiction, impairment of constitutional right, violation of due process, and malicious prosecution, right? So the notice of abatement here is what you can do before certain emotions and things of that nature. You can do a form of abatement. All right, so, and also when it comes to the lack of jurisdiction, meaning that if there is no potential law here breaking, then there is no jurisdiction for the court. So like what we're saying, since we're exercising the Second Amendment in the first place, then that means that there is no jurisdiction here because there's no violation here. So now, also the impairment of constitutional rights. They cannot use legislative laws to impair obligations of contracts. And that contract is the Constitution, right? So make sure you know that. And we're going to do it based upon violation of due process because now they're trying to take a form of right away without going in through due process, right? And them taking you to court and not being able to, it also comes into a form of malicious prosecution because it is in malice, right? All right, so notice to all parties here, okay? And this is a notice of abatement. So this notice of abatement is hereby served to whatever the name of the court and all interested parties in the matter of the case number. The purpose of this abatement is to challenge the jurisdiction of the court, protect all inalienable rights granted by God and recognized by the U.S. Constitution, and distinguish between the natural person, John H. Doe, and the legal entity, John H. Doe, right? And yes, I know it can be uppercase, lowercase. All right, so this notice further addresses violation of due process and malicious prosecution. John H. Doe, a natural person created by God, endowed with inalienable rights that cannot be abridged, denied, or diminished by any government or legal entity. My existence and rights are governed by God's law, which is the supreme law of the land, and supersedes all legislative enactments that conflict with these divine principles. So in Hale versus Hinkle, 1906, recognizes that a natural person's rights are inherent and cannot be diminished by statutes. The individual may stand up on his constitutional rights as a citizen. When they say citizen, they mean private citizens. So Murdoch versus Pennsylvania, 1943, the state may not impose a charge for the enjoyment of right granted by the federal Constitution. So again, the state may not impose a charge for the enjoyment of a right that has been protected. It should say protected because the federal Constitution does not grant right. It protects rights. All right. Only rights can be granted by God. Everything else happens through legal construct, which is privileges. Right. So distinction between natural person and legal entity. All right, the name John H. Doe, represented in all capital letters, is a legal entity or straw man created, all right, by the issuance of the birth certificate by the state. This entity is distinct from the natural person and operates within the realm of statutory law, which governs commercial and administrative activities. So any attempt to impose statutory obligations on the natural person by conflating these two entities is unlawful and void. And here's the reason why, because the entity is only used for commercial purposes only. It was never to be used against you to hold you for liability for charges that are unrelated to anything that deals with Constitution. There's no actual real crime of you bearing arms. Think about that. You can bear arms right now, and they can't consider that a crime because you have a natural right to do that. Why would you give away a natural right to a government that you have that exists? That's insane. Nobody would do that. That was the whole point of them running from what they were running from in the first place, because a lot of their natural rights were being taken. They were even being killed based upon what they believed in. So you got to think about that, which is why they express liberty of conscience, which means each individual has the right to decide what is religious to themselves and what is also sacred to you. You decide that. No one else can, right? So keep that in mind, all right? So the Willing Steel Court versus Glander Hill. Well, we on Crandall versus Nevada. Recognize the natural person retain rights distinct from legal entities. Willing Steel Court versus Glander affirms the distinction between state-created entities and natural persons, and the right to bear arms under the Second Amendment. So the Second Amendment of the U.S. Constitution states that the right of the people to keep and bear arms shall not be infringed. It says shall not be infringed. Okay? Shall not be infringed. Okay? So, now, and see, somebody said OKC has a statute saying pointing a gun is a felony. Well, if you point a gun in intentions to cause harm, then yes. But if you are pointing a gun in intentions to in self-defense, then no. It's all about willful intent then. You see what I'm saying? Yes, if you point it at a person, is it for self-defense or is it because you want to cause harm to this person? That's what makes the difference. Willful intent. And now, based upon the situation that has occurred between the two individuals, we can determine whether it was willful intent or whether it was in self-defense. That's the now, and that's the right to bear arms based upon you, using it to make war. That's different. That is a difference. Right? All right, so let's see, where was we at? John H. Doe was exercising his God-given right to bear arms for self-defense. At no point did John H. Doe use the firearm or just say arms in an unlawful manner, nor was there any injury or threats to others, making his arrest a violation of his constitutional rights. So again, if nobody's harmed, there's no one around to prove that you were with ill intent to cause harm, then you have the right to bear arms for your own self-defense. That's just simple as it goes. Like, man, you need to understand that. So District of Columbia versus Heller recognizes the individual right to possess firearms for self-defense. McDonald versus City of Chicago applies the Second Amendment to the states, ensuring that the state and local governments cannot infringe upon this right. And they can't, because the Constitution says it cannot be infringed upon. So that means they can't create legislative laws to infringe upon a natural right, which takes us back to Article 1, Section 10. This is why this becomes federal. This can easily become in a federal jurisdiction to be handled, and you can do this as a tort claim against any individual who is trying to take away a right that you naturally have that is protected by the federal Constitution, because it ain't granted. God granted the right. God the one gave you the conscious state of mind to understand how to form weapon in defense, which gives you the right to bear arms. See what I'm saying? That's just a natural conscious right that you have. You understand. If I pick up a stick, I can use this to protect me. And then it is what it is, whatever that may be. But again, so now we got to do void for vagueness doctrines. If John H. Doe was arrested under that vague or overly broad statute, such a law would be unconstitutional under the void of vagueness doctrine. Law must provide clear guidance to individuals, and failure to do so renders them unenforceable. All right? So the Papa Cristo versus City of Jacksonville struck down a law for being unconstitutionally vague. The grade, I guess that's grading, versus City of Rockford, 1972, held that laws must provide a reasonable opportunity to understand what is prohibited. So John H. Doe's carrying of arms was an act of necessity, as it was for lawful self-defense, a greater legal principle than any conflicting statute. This defense applies where there is an imminent threat of harm that cannot be avoided by other means. Simple, right? And that means based upon potential future harm. You have the right to be in preparation of defense at all times, right? United States versus Bailey, 1980, allows for the necessity defense when actions are taken to prevent imminent danger. So strict scrutiny standard for statutory infringement. Statutory laws that infringe upon constitutional right must meet strict scrutiny. The government must prove that law serves as a compelling interest and is narrowly tailored to achieve the interest without infringing on the right to bear arms. So again, if we go back to what it says about the right to bear arms, it shall not be infringed upon ever, right? There's no excuse for it to be. That's stupid. You know? So now, Sherbert versus Vernon established that the laws burdening fundamental rights must meet strict scrutiny. They have to. So now this is a form of malicious prosecution because being subjected to malicious prosecution as he is being targeted for exercising his constitutional right to bear arms. Malicious prosecution occurs when legal proceedings are initiated without probable cause or with improper motives. Again, if they can't prove your willful intent to go and cause and make war and cause harm based upon some form of threat, etc., then absolutely this is without probable cause. And since it's without probable cause and improper motives, that also means that what? They lack jurisdiction because there is no harm. There has no crime been committed. So there is no jurisdiction for the court here today. That's a fact, right? So, Albert versus Oliver recognized a claim of malicious prosecution when Fourth Amendment rights are violated. So, protection against unlawful detention and habeas corpus. So, someone's in jail, they prolong the detention without being brought before a magistrate, violates his right to a speedy trial under the Sixth Amendment. John H. Doe can petition for a writ of habeas corpus to secure his immediate release. Well, 1972, a delay in trial violates the right to a speedy trial. All right, reaffirm the importance of the habeas corpus in protecting individuals from unlawful detention, which also takes us back to this. If they're going to arrest you for a criminal charge here, right, they're supposed to take you straight to the magistrate with all evidence that they have to declare, and then the magistrate then gives them the right to fully make a full process of arrest. So where they will arrest you, take in all the evidence, go and process you and everything, and bond you and set up a full court date for you, right? That's how it's supposed to happen. Simple, right? It ain't supposed to be nothing else. But that's not what they do to you. They take you straight in and process you. They do not take you to the magistrate. So that means there is a delay here. So since there is a delay, some may see the judge in 72 hours. Some may not see him in a week. And I've been that one that's been somewhere and been arrested, and it took a week. And that right there is a delay. And the individual who makes the arrest is the one who has to bring you forward before the judge, not some bailer or something like that, because they're not the one who made the arrest. It's the actual individual who makes the arrest. So since you notice that these type of things is not happening, then guys, you have to understand there's a failure of due process of law. Drop some ones if you with me, yo. Drop some ones. There is a failure of due process of law. All right. So know that part, right? So now, since we have a lack of injured party, there is no injured party in the case, as John H. Doe actions and bearing arms did not harm anyone. Without an injured party, the state lacks standing to pursue a criminal case against John H. Doe. Case law, Schneck versus United States, 1919, held that conduct that does not create a clear and present danger cannot be punished, applying a similar principle to the bearing of arms when no harm is caused. Ain't no harm caused. In light of the above assertions involving violation of John H. Doe constitutional rights under the 2nd, 5th, 6th, and 14th, the lack of jurisdiction and malicious prosecution, I hereby demand that all proceedings in the case it be abated and the court case cease and desist from any further actions against the natural person, right? And hereby reserve all rights, including but not limited to my rights under God's law, the U.S. Constitution, and the common law. No part of the abatement shall be construed as a waiver of any rights, nor shall it be interpreted as consent to jurisdiction or statutory law, right? And that's just pretty much it, all right? That's actually what I sent them to handle a situation for her. And all cases was dismissed. That happened in Texas, so sure was. And that is what's supposed to happen. You know what I'm saying? All you have to do is truly understand the law. Like they can't play with the law. The law is not to be played with. The law is what keep everything in order and structure. But again, as I said before, we were cut off earlier on the one before the live before this, guys. Like again, can you think of a time that you took an oath to the Constitution? And if you did, that means that you are a public servant and you are in service to the people. So when you hear service, servant, that means the people are in sovereignty. All right. And that means those who serve the people are being ruled. So in order for that to happen, that means the people got to be aware of the law first. Right. And then once you become aware of the law, then you can make with rulership. You see what I'm saying? So my whole point is it's your duty as the people. You are the one who is in the kingship. You are the one who sits on the throne. You are the one with the power of the prince. It's you. But if you're not aware of who you are, if you're not aware of your rights and things of that nature, because they the one said they would serve you. So hold them accountable to the actual contract. You see what I'm saying? You need to make sure that you hold them accountable to the contract. Well, what's the contract? The constitutions that they took an oath to. Right? Hold them fully accountable. And then some of y'all say, well, they don't take oaths no more. Well, now it's your duty to hold them accountable to hold an office. That's where quo warranto tolls come in. Because now they're holding an office illegally. But if the people just gonna allow it, that's our problem. We the ones that's not involved in our own government. You think just because you pick some people, that's why, like I said last time, I don't vote. I don't care about voting. It don't matter to me. Because what matters is, are we gonna hold the person that sits in that seat accountable? We don't have to worry about voting for someone who we feel is going to be a good leader or whatever. Just make sure they all will be a great leaders if you hold them accountable to what they're doing in those seats. That's the difference. But if you ain't going to hold somebody accountable, like what does it matter that you voting? Because if they do something wrong, you're not aware of it. Again, I keep saying the Pentagon just failed an audit. Nobody's aware of this. You don't care. And then when you do find out about it or someone tells you about it, oh, man, they're lying. Man, they're lying that they wouldn't do that. You know what I'm saying? I'm like, bro, are you naive? Yeah, you're naive of the same country that gave people syphilis. You naive of the same people who just, man, listen. They just infected so many people in 2019 and 2020. And now having to come out to admit this type of stuff, of what they done. So that's why I'm explaining this to you. Like now it's our duty. Like we can't keep putting stuff on people you think that you put into these seats and they all go in for their own interests. All of them. They all go in with their own interests and based upon what's going to build for their particular, industries and stuff like that they have going on, right? But see, the difference is the only difference is the reason why they don't like Trump because he was already he was already wealthy. He didn't need to do anything to make money. The only thing he said, I'm gonna make more money by making the people more money. And the way we're going to do that is we're going to make America great again because we're going to bring all the industries back home. We're going to make the people go back to being producers and stop being the most consumerist country in the freaking world. And if you don't want that, well, I'm sorry. I don't know what else to tell you. Keep suffering. But it all goes back to you not knowing the law. So when somebody that comes in and they know the law and they shake up everything because you got people in here that's been breaking the law, it's kind of like being at work. When you get a supervisor that actually runs their job, ain't no cutting corners, and now we don't like this motherfucker because I don't like him. I don't like how he run it. Why? Because you can't go on break for 50 minutes no more. You know what I'm saying? Like, people don't like to actually have to deal with the instruction. And I go through that now. Even dealing with these classes, people don't want to follow certain instructions. People will try to make it their own way to get what they want. And it's not like that. You got to think about it. Like, you can't go tell, let's say you miss a sale. And you miss a sale with Walmart or whoever. You can't go say, hey, I missed the sale yesterday, but I'm here today. Can y'all put this on sale for me? No. One, because when they do sales, all of their stuff are what? Bonds. That's why it's called a coupon. You're getting a coupon that's connected to a bond to discharge off some particular product. So basically, it's insured. They ain't losing. You didn't think about that, though, did you? But that goes all the way back to understanding rights, understanding interests, things of that nature, right? Now, before we get ready to read this other one, man, let me know that y'all with me, man. Drop some ones, hit the share button. About to read the second document for you guys. So any of your people that you know that got gun charges, non-violent gun charges at that, bring them right here right now. They need it. They probably facing some type of 12. I don't know, man. They give out some numbers, man. Let's go. Yeah, I just want to make sure y'all vibing good. We vibing good. Yeah. All right, man. First and foremost, man, again, we just give thanks to the Almighty, the source of all things, right? Source of all things. It's beautiful. Last year, I pleaded guilty. Can I now squash my probation? You pleaded guilty of what? What did you plead guilty of? Let us know. What did you plead guilty of? Eric Warren on TikTok. What you plead guilty of? We are waiting to know. Such a beautiful day, y'all. I'm telling y'all, it's lit. It's lit out here. You know what I'm saying? You wake up with beautiful people and hey. No. You know what, though? I will say this. It's a good thing that it did cut off because I had to get off and my mom called and she told me that my grandmother was in the hospital. So prayers up to grandma. She'll get to feeling better. But let's go. I don't get an answer from Eric Warren. He didn't say anything. So we're going to jump back into this. Let's dive in. All right, so now this is a formal request. Now we're going to do this, the right to bear arms, according to the Clearfield Doctrine. So this has a little bit more flavored stuff in it and things to bring out towards the public eye to view in case of any form of infringement is going on, right? So we're going to ask a couple of new questions in this one, and this is going to be a little different, but with the same objective, still protecting the rights that we have, but also questioning like, hey, are you guys in here doing commerce? Because if you are, then, yeah, that's a civil nature. It's not supposed to be in criminal. This court is mixing two jurisdictions at the same time. We can't do that. So you need to make up your mind because now I can't say I understand the charges of anything because I don't understand the nature of this court. I don't understand the nature of the court. And if I don't understand the nature of the court, then I don't understand the nature of the charges. Because if they're commercial, well, I need a contract. And since they're commercial, then guess what? There's no authority and jurisdiction here for you to adjudicate anything without some form of contractual agreement with me saying that, hey, I agree for my Second Amendment right to be taken away and be governed according to whatever policies that you have. I need to see that. Right? So let's dive into it. Let's dive into it, right? Let's dive into this. Okay, so formal request for a full disclosure of commercial activities, separation of natural person from legal fiction, challenge the delegation of authority, and demand for abatement of action regarding the right to bear arms. So, I, your full name and natural person, submit this formal request for full disclosure regarding the court's involvement in commercial activities. Why? Because they gave a bond. If you had to bond out, commercial activities. If there's any monetary value dealing with this in any shape, form, or fashion at any given specific time, then automatically we are dealing with commerce, law merchant, admiralty, and maritime jurisdiction. I want everybody to know that. And if you don't know that, you better learn that right now. All right. So, involvement in commercial activities and its jurisdiction in the matter concerning my right to bear arms, as protected under the Second Amendment right of the U.S. Constitution. This document establishes the clear distinction between the natural person, myself, and the legal fiction. Right? Challenges the court delegation of authority and addresses the commercial nature of bonds and financial obligations in this case. What are you guys doing? Right? So the natural person is distinct from the legal fiction, which is corporate entity created by the state through the issuance of a birth certificate, and the natural person possesses God-given inalienable rights, including the right to bear arms. So one was created by the state and the other one created by God, which means they are brought into two separate whole existence. One is for commercial purposes, and the other one, well, it's for the divinity of what God established here for you for, and the purpose that God established you here for, right? So the legal fiction, on the other hand, is subject to statutory law and commercial obligations, which do not apply to the natural person without expressing their consent, which brings us back to what I said earlier. There has to be a form of contract of me showing I waived a right. Right? So as a natural person, I do not consent to be treated as a legal fiction. And any attempt by this court to impose statutory obligations upon me violates my constitutional and inalienable rights, right? So we have a legal proceeding here, District of Columbia versus Heller. The Supreme Court confirmed that the Second Amendment right protects the individual right to keep and bear arms for self-defense, McDonald versus Chicago. The case incorporated Second Amendment right to bear arms, the states making it applicable under the Fourth Amendment. Now, here, we're going to challenge the court's jurisdiction under the Clearfield Trust Doctrine because this court has entered into commercial activities. Again, if you bond out, commerce. Anytime, if they trying to charge, if there's penalties added to these charges, commerce. These are all civil in nature. Criminal does not deal with forms of civil restitutions. It should not. It should never. Because that literally saying is what? That takes us back to that it's not supposed to be, justice cannot be bought, right? There should be no monetary value of anything in justice because what happens when there's monetary value? See, it takes us to that movie that's on Netflix. Somebody tell me, because it's about the little army dude and he go to this town riding his bike and they hit him and he fall off of it. They take his money and all of that. And the way they schemed, they was running because it was based upon the bonds that they had, and it was bringing in monetary value into that county by doing the stuff that they were doing. So my point is, when you involve money in this, you involve interest, and people get paid, and that means that if the money goes up at the county, then that means they get raises and stuff like that, and bonuses and all of this different stuff. So really, truly, they got an interest when it comes to this bond shit. Right? Think about that. And that right there should let you know the courts and everything is acting fully in commerce. They can't lie about that. The more conviction rates they have, the more money they're going to be getting. This is a fact. Right? So now, this including the potential issuance of bonds, fines, or other financial obligations, which places the court within the realm of commercial law. According to the Clearfield Trust Doctrine, Clearfield Trust Company versus United States, 1943, when the government or its agents engage in commercial transactions, they lose their sovereign immunity and are required to operate under commercial law, just like any private entity, which is why they go and use administrative laws against you. As a result, the court is acting as a private corporation in this matter and is subject to the same rules and obligations governing private entities. This includes adhering to the UCC and other relevant commercial laws. The court's commercial involvement strips it of its sovereign immunity, and it must provide proof of its delegated authority in any valid contractual agreements that justify the imposition of obligations on me, a natural person. So they got to prove where you are waiving your inalienable rights. Show me a contract. You know what I'm saying? Since you want to operate in civil nature and charging me, because again, you can't charge me for something you didn't take a loss in. So show me where's the loss in me, the right to bear arms. How did you lose money to where now there's a penal sum? Where was the damages and things caused? See, these are the questions that you got to start answering now, because we're in commerce. Since you want to say there's money involved, show me where there's a loss. Because the only one taking loss right now is me based upon time and labor. Because I'm laboring to you guys for this specific event and I ain't getting paid. But I'm definitely threatened that if I don't be here, that I could go to jail or a warrant would be placed out for my arrest. So since I'm in labor and service for this court to carry on today, and it's all involuntary servitude because I don't agree with the whole method and nature of this presentation you're doing here today. This is a fact. Now, yes, they're going to be pissed off that I said something like that. Yes, they're going to be mad. Yes, they're going to poke their chests out like because they went to a school to learn law or be taught a program of way of learning law. And now they got, they want to contempt of court and all of that good old type of shit. And that's cool. I can ride with it. But guess what? I promise you it's going to be a whole tort claim coming to you. A whole tort claim. Because you're in full violation. Right? So if you ever had jurisdiction, you lost it when you start mixing up these charges. And you lost it based upon due process of law. You've been lost it. A long time ago, right? So that's another thing, right? So since the court is engaged in a commercial transaction, it can no longer claim sovereign immunity. It is required to follow commercial laws, and therefore any obligations imposed on me, including fine, bonds, or financial instrument, must be based on valid contractual agreement that I have consented to. So, right to contract, Article 1, Section 10. The U.S. Constitution protects the right to contract in Article 1, Section 10, which prohibits any states from passing laws that impair the obligations of contract. As a natural person, I retain the right to contract or not to contract freely. The court cannot impose statutory obligations, including bonds or fines, unless there is a valid contractual agreement with my express consent. The court must provide evidence that I, as a natural person, have entered into a binding contract that consents to the statutory obligations. Without such evidence, any imposed obligations are void, right? So, Dartmouth College versus Woodward, the Supreme Court confirmed that the right to contract is protected from governmental interference. There is no jurisdiction here, family. So now since there's bonds and stuff like that, and anytime that there's bonds and you had to sign up on some bond, now you are considered a form of entitlement holder, you are considered a registered owner of it, and you are considered a form of, a grantor of it, and you can be considered a investor of it. A lot of different words, right? So if the court has issued any bonds or financial instruments in relation to this case, I formally request the full disclosure of the origin, nature, and parties involved in these instruments. The courts must demonstrate that these bonds were lawfully issued under a valid contractual agreement with consent as a natural person, and if no such contract exists, I hereby reject any and all bonds and financial instruments related to this case and demand that they be discharged pursuant to UCC 3-603 and settled in lawful money. Immediately. So, the right to bear arms under federal and state law. The Second Amendment of the U.S. Constitution guarantees the right of the people to keep and bear arms to keep and bear arms shall not be infringed. So any statutory attempt to curtail this right, including the imposition of fines or penalties, is unconstitutional. In addition to federal protection, I invoke protections afforded by whatever state, and then you'll put the article of that state. Every last one of them has the right, to protect the right to bear arms, right? Which also guarantees my right to bear arms. Any attempt to restrict this right at the state level is a violation of both the federal and state constitutions. So in the legal proceeding here at the court, the Catano versus Massachusetts, the Supreme Court confirmed that all forms of arm, including non-lethal weapons, are protected under the Second Amendment right. And People versus Ogler in 2013, the Illinois Supreme Court reaffirmed that states cannot infringe upon the constitutional right to bear arms, right? So the court's issues of bonds or financial instruments in this case is inherently tied to Federal Reserve notes. While the bond itself may not directly be a FRN, any redemption or settlement of the bond will ultimately be paid out in Federal Reserve notes, which are debt instruments under 18 U.S.C. 8. And this means the court is engaged in the commercial activities that are directly linked to the issuance of commercial debt instruments as well. I reject the settlement of any financial obligations, including bonds and FRNs. I request that all financial obligations related to this case be redeemed in lawful money pursuant to 12 U.S.C. 411, as FRNs do not meet the constitutional requirement at this time for lawful money, right? So, acceptance for value of the financial obligations. So, in accordance to the UCC, I hereby, we can put for value received or set for value, any bonds, fines, or financial obligations related to this case, including those issued to the legal fiction. And I request that these obligations be discharged and settled in lawful money. So our endorsement would be for value received, accepted for value, return for value, settlement, and closure of the account, charged to the same of the United States as obligations of the United States, redeemable in lawful money, pursuant to 12 U.S.C. 411, right? And then you would actually make sure that you sign off as the registered owner, all right? And that's just what we're doing. So the legal proceedings here was UCC 3-303. You can actually find these within your state. So you can reference to those because the state has fully adapted the UCC in some shape, form, or fashion. Right? So value is given when the obligation is accepted. And 3-412, the issuer, meaning the court, is responsible for settling the obligation. All right, and UCC 3-603, the obligation can be discharged even if the court refuses the payment. All right, now, here's another thing. When you do something like this and you tender a payment in a court and the judge refuses it, bro, they just acted in commerce. You can't refuse a payment. If you refuse a payment, that is an act in commerce, which means you're being dishonorable. You can hold them accountable for that. And it's not the duty of the judge to accept it. It's all based upon, one, whoever the plaintiff may be that you're dealing with, whether to accept it. And that has happened in eviction cases and stuff like that. And the judge needed to show delegation of authority where they were given the power to accept or not accept some form of payment coming from the particular plaintiff. Now it looks like conspiracy and all of this stuff, right? But again, all of this takes is for you to be aware of who you are. And I think that's the situation where people stop it because they're not aware of themselves. You got to be aware of you, right? So now, the final demand for abatement, given the court's lack of jurisdiction over the natural person and its involvement in commercial activities, I hereby demand that all proceedings in this case be abated. Any further action against the natural person without proving jurisdiction or authority will result in legal action for violation of my constitutional rights. And as well, the constitutional due process violation, the 5th and the 14th Amendments guarantee that no person shall be deprived of life, liberty, or property without due process of law. By attempting to enforce statutory obligations without my consent, the court is violating my right to due process of law. And I request full disclosure of any and all due process that the court claims to have followed in imposing these obligations. So Goldberg versus Kelly, the court emphasized the right to due process when a person's liberty or property is at stake. Remember, your rights is your property. So we want to challenge actions under color of law. Any actions taken by the court under statutory law without my consent constitutes action under color of law, which is not lawful authority. The U.S. Supreme Court has ruled that acts done under color of law when they infringe on constitutional rights are unlawful and void. So, legal proceeding, ex parte, Young, 1908. The court ruled that actions taken under federal law that violate constitutional rights are not legitimate and subject to legal challenge. So, and that's just pretty much it. We're done. The conclusion is just reading everything back over. And that's what it takes to actually, handle these types of cases, yo. And like I said, this is very simple. This is very easy. They're not going to want to fight this, especially if you present this right. And once you present it right, they have to prove willful intent for you to go and make war and cause harm against somebody. They got to prove it. And all you got to do is say, well, this is self-defense. I'm exercising a higher right. Show me where I had willful intent to disobey this law when I was only exercising a higher right, which is the constitutional law. So now that means that this law, the statutory law that you're screaming about, it infringes upon the Constitution, which takes us back to Article 1, Section 10. So now the state can create legislative laws that's going to impair this form of obligation, right? Can't do that. So with that being said, guys, that is how you would handle that situation when it comes to your right to bear arms. And people that are constantly having to deal with these type of charges, when it's insane. I mean, we got 16, 17-year-olds, 18, 19, 20, gone for. And once they get locked into the system, they don't have that type of money. So they bouncing back and forth from one to the other based upon not being aware of these type of things, yo. So we got to be able to change the narrative. If you guys going to be out here toting guns because they said you can or whatever, then you need to know the law. Seriously. And be careful. Because they do certain things to try to provoke you. The whole open carry, well, that was to provoke the stand your ground. And to stand your ground just goes back to, oh, I'm scared of you. And I always say, I'm scared. So ever since I learned that, man, I'm scared. Hell yeah, I'm scared of everybody. Yep. And I have the right to defend myself from being scared. And that's a lot. And they use that. But you got to understand that. So y'all be safe. Don't just be out here toting it because you can. Like there's a reason. And I feel like a lot of that invites some stuff and a lot of it don't. It just depends on when and where you at. But to each his own. You live by it, you die by it. That's a fact. You live by it, you die by it. And that's whatever you live by. But how do you guys grade this today? So let me know. What's y'all thoughts on this? And y'all got any questions at this time? Please let me know. Please let me know. Do you guys got any questions at this particular time? You are more than welcome to ask any questions that you have. You're welcome. Ask away. If you ask me a question that's not pertaining to what we talked about today, I'm not answering. So I'm letting y'all know that now. And I know somebody gonna do it. So, see, you just asked me about something that it doesn't matter. Neither one of those makes it about a negotiable instrument. So, but I don't want to answer that. How can I get copies of the info you provided here? If you want these type of things, you can go to my website, ingodwetrustacademy.com, and you can look for the right to bear arms, and it'll come up there. I mean, a court warrant tow is just something you issue out to someone that is illegally holding an office or doing something illegal in the office that they're not supposed to. So that means they're usurping powers that they don't have. And then so you would do a court warrant tow based upon someone doing something, or either they're using a particular office to abuse power, or they illegally entered into an office or holding an office. That's what you would use a court warrant tow for. In Kansas, someone recently warned about switches. Yeah, because they can't tell you how to have a right to bear arms. I don't care if you got the fastest gun on the earth. I don't care if you got the fastest gun on the earth that shoots 100 rounds in whatever seconds. You can have it. It's your right to bear arms. Can't nobody take it away from you. But you can't use it to make war. Just in defense. That's the absolute truth. Anybody else? What is y'all questions? Later on today or tonight, we'll do a Q&A about just whatever type of questions. But right now, we're going to stick to what we own. Stick to what we own. Do anybody got a family member that's dealing with this type of stuff? Or even yourself? Are you dealing with gun charges right now? Instead of asking y'all for a question, what y'all learned then? What did y'all learn? Is what I want to know now. Yeah, tell me what you learned. Tell me what you learned. Dealing with courts, not gun charges. That's good. Can you explain jurisdiction a bit? How would the court lack jurisdiction? Because if there's no crime, there's no jurisdiction. It's not a crime for you to have the right to bear arms. So if there is no crime, then there's no jurisdiction. And there's no jurisdiction or sovereign immunity because they're acting in commerce. So everything is a violation of due process. When they violate due process, they lose jurisdiction. So we challenge the jurisdiction based upon the lack of due process and also that there is no actual crime here. So that's just basically jurisdiction in a nutshell, for real. I have a 20-year-old gun charge. Can I get off my record? Yeah. You can literally go back to that and explain to them how it was your right and your right to bear arms. And if it's a non-violent gun charge, that they needed to show proof how you had willful intent to cause harm. And if they can't, then this is a violation of the whole due process. That means it's void ab initio, and jurisdiction can be challenged at any time. So, yes, you can go back and challenge that right now. The question was asked if the guy already pleaded guilty. Well, most of it was on the coercion in the first place. And that if you had a public defender, then you get to do a retrial based upon negligence because this person never seek to protect your rights. And that you knew that you had a right to bear arms. The court needed to prove willful intent to disobey a law when you was obeying a higher law. So they would need to do that. So, yeah, you can go back. It's just all about how you put it down, though. Just all about how you apply it. I learned the real meaning of commercial law and how everything is civil in nature. And that's true. It can't carry both. Well, jurisdiction kind of do deal with an area sometimes because they'll say jurisdiction is based upon something happening within that jurisdiction. So if it happened within this district, then this particular court would have the jurisdiction. But they don't have jurisdiction because there was no crime there in the first place. So they don't got jurisdiction. And they don't got jurisdiction because they're going to violate due process of law. Jurisdiction can be challenged at any time and in any court. Yeah, you can file a tort immediately. If anybody calls you harm, you have the right to a tort claim. Learn about willful intent and due process. Yes, sir. Absolutely. Anybody else, man? Anybody else? Let me know. Smell like the food is cooking. Oh, that's just My nose just want to smell something. Mm-hmm. No more questions, I see. All right, so since that's all you guys got, man, let me don't forget what we have coming up. Yeah, I'm trying to stick to the subject. I ain't trying to answer something that ain't got nothing to do with what I'm talking about today. We'll talk about child support and that other stuff another day. Can you come back with a live on how to do a tort and where to file it? Yeah, we can do one on that. I mean, this particular situation, we can file it in the federal court or we can file it within the state. It just depends on which one we want to use. If we want to use the state constitution about the right to bear arms, etc., then we can file it in the state court. Or if we want to use it based upon the federal law, right, and that the state issued a legislative law that infringes upon it, then we can do a whole full injunction on that as well in the actual federal court. So, yeah, we can do it, man. All right, this Friday, guys, make sure that you will be involved in the White Friday sale, 50% off of everything except for the conference that's coming up, certain merch, and the work section, gold options, and consultations. This account will be applied at checkouts November the 29th, 2024. To order, visit InGodWeTrustAcademy.com. Donations be made via website, via Cash App. That is EBEY, eBay, which is 619-2020. So, again, everything will be half off on there for you guys, except the things that is mentioned here, just not included. Also, work session again tomorrow, okay? So, work session is Mondays and Wednesdays, 11 a.m. Central Time. Mondays and Wednesdays is 6 p.m. Central Time. This is like a free session, kind of like today, but the difference is you'll be in class with us, able to ask your questions. So make sure that you do everything that follows to receive this. And, just like, sometimes we give stuff away. We're giving something away from Monday. So just certain things like that. So, guys, just make sure that you tune in with us and enjoy the sessions. We're going to go up until probably March. So, private administration class we have in the conference here in December the 7th in Huntsville. So it's at 10 a.m. to 4 p.m. Central Time. If you can come in person, please do so. It's $250. For those of you that's going to be traveling next week, man, safe travel to you guys. Can't wait to fellowship with you all. Live stream is $200, so make sure that you get locked in. Like I say, we're going to be talking about all of this. Even what I showed you today is part of what you call a private court administration, because we're giving a notice of liability and a notice of abatement. Going to show you how to do Mysterious ICAR, which you just asked for as well, how to send certain notice of liabilities to these particular officials or people who are acting in official offices and causing harm, and how to make them responsible for it and letting them know that, hey, you lost sovereign immunity because of the violation of due process law, etc., right? So just we're going to talk about that. We're going to speak on negotiable instruments, how to deal with the IRS, how to deal with, dealing with stuff in trust, administrating those things. Pretty much, like I said, everything I've done the whole entire year is going to be in here. So we're going to be dealing with courts, creditors, IRS. We're going to be talking about taxation, how to live free from taxes as well. I've already did one on that, but people want to go in a little bit deeper on it, and we're going to talk about those things as well. So as much as we possibly can, we're going to pack it into this session, yo. And if it's not enough, where I feel like it's not enough, I might even do a part 2 and just have everybody on live stream. We don't know. We're going to see how much we can pack in there, though. So, again, appreciate you guys. As always, it's always love. Make sure that y'all share. And, I'm going to leave this up for a while, man, so y'all can, do what y'all want to with it, man. But just definitely know that this could definitely help people. I have helped people using these documents and, so it's up to you to do what it is that you want to do. Now, for all y'all people that be complaining about why are you charging for private administration? Yo, we just showed you how to do it in one way. So that's what I'm saying. Like, the people that pay for this that want to come, that's because they want to be there. They enjoy the vibe, right? That's the difference. Okay? Because we freely give this information daily. But my question is, where do you guys be at? Where y'all be at? They don't never be present when it's going down, do they? Drop some ones if you with us, man. We up out of here. So, I did a thing. Yeah. I got to claim some land. And I'm real proud of myself for this. So, man, this is dope. MNRP literally gets to say that it has land, specific land, that is under its jurisdiction and governed by the Constitution, okay, of this particular de jure government that you're looking at back here. Man, I don't think you know what that means. But in due time, you will. For sure, in due time, you will find out. And I told you I was gonna do it. I told you I was going to do it. And it's happening. It's happening. Just tell them. It's happening. We coming. They can't stop what's already destined to us. You know about tax lien sales for acquiring real estate. I know you don't have to pay any type of tax when you are the ultimate consumer. That's what I do know. So if you're the ultimate consumer of the house, then why? Then why? You know what I mean? You don't got to. So yeah, that's one of my things I'm sharing with y'all, man. This is about to be dropped off, taken care of. Such a beautiful thing. Is y'all ready, man? I got a lot to really tell y'all and show y'all that I got going on in the works. Like, I'm always working, so don't think I ain't working. My job is to stay 10 steps ahead of y'all anyway, so I can come back and tell you. So it's beautiful, yo. But yeah, man, we got the whole, you remember I did the one on land patent claim. I showed you guys that. So we got the whole land patent. Yeah. Ain't God good. I think we'll do the Q&A later on tonight or something. After I get done, we'll hop on here. We'll say about 9 Central. So if y'all up, you know what I'm saying? I know some of y'all sleep, go to sleep early. I'm a 2 o'clock, 1:30, 2 o'clock type. And then be up at about, well, hit like that. I've been sleeping a little extra longer for some reason, but we can do it after I get done working out today, because I didn't work out this morning. So yeah, it's about 8:39, somewhere off in there. We'll jump on here. That's what we'll do. I'm out of here, man. Y'all have a great and beautiful day, man. I'll see you guys later.